So a case is now requesting that the Supreme Court take the power of review away from the lower courts in the New York concealed carry cases, and this petition requests that the court instead review the cases on their own before the lower courts actually issue their judgments. So let's talk about this. But real quick before we jump in this video, if you think it's time for the Supreme Court to once again uphold our right to keep and bear arms, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is Kershaw Knives. Kershaw manufactures close to 1 million knives in their US factory every single year. If you need a $20 Walmart knife or maybe even a $200 US made automatic knife, Kershaw has those covered. Also, recently Kershaw dropped their new 2023 line of various knives, including a US made OTF automatic knife. Kershaw always makes high quality, durable, and aesthetically pleasing knives. So I highly recommend Kershaw Knives. I carry one of their knives every single for my EDC. And right now, if you use my code 20Scholar, you can get 20% off of your order and also free shipping on orders of $100 or more. So head on over to Kershaw Knives, use that code, and thank you again to Kershaw for sponsoring this video. So as I mentioned in the intro, in this video, we will be discussing a case that is now asking the Supreme Court to take review power from the lower courts on the whole New York Concealed Carry Improvement Act issue and to instead review the case on their own before there is a judgment by the lower courts. The case we will be talking about in this video is called Gazzola v. Hockel. The case involves a challenge to the state of New York's CCIA law, which they passed in direct defiance to the Supreme Court's recent decision in New York State Rifle and Pistol Association v. Bruen. This case is different from some of the other challenges that we focused on the channel because this one focuses on the impact of the CCIA and what impact that has on dealers and gun stores. These businesses argue that the CCIA is unconstitutional because it violates the Second Amendment and also the Bruen decision. The businesses also argue they are critical and a critical component to the right to keep and bear arms, and the CCIA attempts to essentially regulate them out of existence. The plaintiffs in this case filed their original lawsuit on November 1st, 2022 in the Northern District Court of New York. In the lawsuit, they argued that the CCIA violated various constitutional rights, including the 2nd, 5th, and 14th Amendments, along with also violating federal preemption. They argue that most of these laws in New York need to be struck down because of how they create such an unconstitutional regulatory burden on these dealers. They also argue that the law was designed in a way that makes it pretty much impossible and makes them incapable of being in compliance with the law, and really that the whole goal with this was essentially to shut them down or subject them to criminal prosecution. In the original case, the plaintiffs sought to obtain a temporary restraining order and also a preliminary injunction, and they sought that from the district court. However, the district court rapidly denied both the TRO and the preliminary injunction in the same order. In fact, the preliminary injunction was denied without even a hearing being held. The plaintiffs then submitted an interlocutory appeal up to the Second Circuit. The plaintiffs sought for the Second Circuit to find that the denial of the TRO and of the preliminary injunction, that it was made in an error by the lower court. However, a 3-judge panel in the Second Circuit denied that appeal, saying that the lower court there, the district court, weighed the applicable factors and found that the district court was indeed correct in denying the TRO and also the request for a preliminary injunction. That then led to the plaintiffs filing an emergency application up to the Supreme Court to essentially stay the decision of the lower courts. That emergency application was filed to Justice Sonia Sotomayor, who is responsible for reviewing emergency applications which come out of the Second Circuit. She recently requested that the state of New York respond to that emergency application, and that is due by January 11th. However, something else really interesting has now developed in this case. Instead of waiting on that emergency application, the plaintiffs have now submitted a petition for a writ of certiorari before judgment. This is a completely different mechanism and is also very rare. This type of petition invokes the Supreme Court's statutory power to grant cert before judgments in the lower federal courts of appeals actually occur. This essentially is a way to bypass hearings and rulings at the lower court level and instead go directly to the Supreme Court. Under Supreme Court Rule 11, the Supreme Court can, anytime before judgment, deviate from the normal appellate practice to review matters of such imperative public importance as to justify immediate determination in this court. And that is what the plaintiffs are seeking here in the Gazzola case. They want to bypass the lower court's hearings and instead have the Supreme Court rule on whether the New York CCIA law is indeed unconstitutional because of how it impacts firearms dealers within the state of New York. In the petition, they argue that this case challenges multiple interconnected statutes arising out of the new laws that impact some 20 aspects of the petitioner's individual rights under the 2nd, 5th, 14th Amendments, as well as their rights as federal and state licensees operating as dealers in the lawful stream of commerce in firearms within the US. They argue this is a novel issue that requires the Supreme Court's immediate consideration. They state this case is the organic progression of the trilogy of Heller, McDonald, and Bruen. They argue that FFLs in the lawful stream of commerce in selling firearms is inextricably interwoven with the fundamental individual right to keep and bear arms. They go on to argue that the Supreme Court has defined what to bear means in regards to the aspect of the Second Amendment's right to keep and bear arms. How that means that you have a right to carry on your person, carry within your home, to carry out in public, that it deals with concealed carry. However, they're arguing that there is a need for the Supreme Court to review and flush out the aspect of to keep in the Second Amendment. They also argue that there appears to be agreement among the justices that the right to keep and bear arms meant that you have an individual right to have arms in your own private ownership, and that you need to have those just in case you need to use those if the government becomes tyrannical, or if you need to fight back against the government or foreign invaders because there is some sort of violation of your liberties or some sort of attack on your nation. Then they state that indeed the historic New York laws required able-bodied men to report for militia training bearing their own privately owned arms and ammunition. In short, they state, firearms and ammunition were not furnished by the state. They were privately purchased and owned by individuals. The Second Amendment has no operational meaning without sellers of firearms like the petitioners. Therefore, the plaintiffs asked the Supreme Court to not wait for the lower courts to issue their judgment on this issue. Instead, they are requesting immediate review from the Supreme Court to review this matter, which is of imperative public importance, according to these dealers. Now, whether or not the Supreme Court will in fact grant this review, in my opinion, is probably unlikely. Again, a review before judgment is something that is much more rare, but has become more popular lately since the Supreme Court has been taking up more of these types of petitions. So I wouldn't say that there is absolutely no chance. However, with the Supreme Court recently denying the emergency application in the Antioch CCIA case, I would lean more towards this not happening. The Supreme Court appears to be giving lower courts much more chances and another chance essentially to do the right thing. That's what they did in the Antioch case. So I doubt that they will outright strip review of this case, of this issue from the lower courts and just issue their own judgment. I would say that they are still going to allow the lower courts, the Second Circuit, the district courts to rule on these cases, hear these issues before they actually step in and do it on their own. But I wanted to bring this onto everyone's radar because it's something that's a little bit different, involves a much more novel Supreme Court mechanism. It's a little bit promising. We'll have to wait to see how this plays out, but it also gives me an opportunity to talk about something that's a little bit not so normal that we don't always get to discuss on this channel, which is a different type of writ of certiorari, which is a review before a judgment. But if we get any more information, I will let you all know. Also, if you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.